So, good afternoon, everybody, and thank you for joining me today for our Solar Lease Essentials, what landowners need to know. My name is Brett Green. I'm an associate attorney here with Woods and Bates PC, beautiful Lincoln, Illinois. I see some participants here who I know. To those, I would say hello. I see some people who I don't know. I'd say welcome to you as well. And hopefully, we can do business in some capacity in the future, form a relationship. I'd like to introduce at this time my dynamic and intrepid assistant, Kate Andrews. She assists me on these solar lease and renewable energy lease projects. She will be fielding your questions today, which you can input in our type bar below, and I'll address those at the end of our presentation. Just as an overview to what we're going to be discussing today, solar lease agreements and renewable energy lease agreements are complex documents with a lot of facets, a lot of moving parts, a lot of things to consider. Today's presentation is not intended to be a comprehensive education on renewable energy leases, but an overview that addresses some of the common questions and concerns that clients that I have worked with have had regarding these agreements, and to provide a basic overview of what a landowner can expect to find in these agreements. So that being said, I think without further delay, we can go ahead with our presentation. So I'll discuss factors that are driving renewable energy development in Illinois and different types of renewable energy contracts that landowners are likely to see. This presentation will focus on solar contracts. I'll then talk about the typical structures and terms that are contained in these agreements, what landowners should expect to see there if they're approached by a renewable energy developer. We'll talk about the benefits and risks associated with these solar agreements and how that's going to affect the landowner and their holdings going forward. We'll talk about legal and financial considerations for landowners regarding these agreements, and then we will address your questions and wrap up. So, a renewable energy lease is an exclusive agreement between a landowner and a renewable developer, allowing them to construct a solar facility on your property. What's driving this in Illinois and why we're seeing such an influx of these types of lease agreements in our practice includes tax incentives that are being offered to developers in order to build these types of facilities, as well as statutory requirements that energy providers in Illinois produce a certain percentage of their electrical output from renewable sources. And although wind power leases are not going to be the focus of our discussion today, these are a common type of lease agreement that I see. Wind leases really deserve their own presentation, which I plan on producing in the not too distant future. Wind power leases will differ from solar power leases in the compensation structure that they offer to landowners. With wind power leases, you're typically looking at compensation based on the type of infrastructure they build on your property and based on the eventual total power outage of their project. These are usually a part of a larger development that consists of many parcels across a large area that are owned by multiple owners. If you are approached by a developer with a wind power contract, you should seek out representation. And here at Woods and Bates, we have ample experience assisting landowners with wind power type lease agreements. So, one major type of solar energy lease agreement that is governed under its own statutory framework is a commercial type development. These are large, comprehensive developments that can involve hundreds or thousands of acres, and these are designed to be tied into the regional power grid and provide power distribution over a large area. The types of infrastructure you'll see associated with these are large, extensive solar panel fields, substations and transformers, energy storage facilities built on the lease premises. Because of the nature of these commercial type agreements being large agreements that serve a large geographical area's power needs, these are less common, though I have represented clients who are contemplating entering into these commercial type agreements and have had some good success in getting these deals executed. So community type solar developments are much more common. That's because these are smaller developments, usually about 25 acres, usually limited to a single parcel that has a single owner, or multiple parcels that are adjoining, typically owned by a single person. These types of developments, these community type developments, are designed to serve the power needs of an individual community. And the power output here is tied directly into local electrical infrastructure. The types of infrastructure they will be looking to build on your property with a community type development are going to include a solar panel array, transmission infrastructure, security, access infrastructure. That's basically panels, wires, roads, gates, and fences. As I said, these are the most common type of agreement that I see, which is why we're going to be focusing on community type solar energy lease agreements today. So a question I often get right up front from landowners is, why did they pick me? Why did they choose my parcel? Well, the developer is going to approach a landowner based on several factors that they've researched and thought out beforehand. They're going to be looking at the proximity of your parcel to a community that has adequate energy demand. The local demand needs to be great enough to justify the expense and effort of building the development. They're going to be looking at the proximity of your parcel to existing local energy infrastructure. The developers generally want to utilize pre-existing infrastructure. The less they have to build, the less expense they have in their project. They're going to use existing local infrastructure to the greatest extent possible. They are going to be looking at the dimensions and the lay of the land of your particular parcel. They're looking for appropriate and adequate acreage that's the right dimensions for their development. Farm ground is typically ideal for this due to its openness, relatively flat terrain, and a lack of pre-existing structures and improvements on farm ground. They're also looking for a parcel that has easy access to public roads, which they can use to run their operation and do their construction projects. They're looking for parcels that are free of encumbrances as far as they can tell beforehand through public records. So different projects will have vastly different terms, although there are many commonalities between contracts. Developers will offer terms based on the specifics of their project that they're undertaking. However, some of the most common terms that we'll see in these types of agreements are an exclusive option type structure. This is where developers are reserving the right to proceed with construction and operations or not based on feasibility studies that they are going to conduct on your land once the lease agreement is signed. These agreements typically consist of three broad terms, three broad periods of time that have different terms applying to each. The option period, or sometimes it's referred to as the development phase, you'll see different terms and different agreements, but they're referring to the same concept. This is the initial period of the lease agreement where the developer conducts their feasibility studies and they'll determine ultimately if they want to move forward with construction, execute their option in order to do so, and move to operations. This is usually a 1 to 2 year period, and the developer will reserve the right for themselves to extend that option period. Compensation structure during the option phase of a renewable energy lease is typically a lump sum payment made to the landowner with additional lump sum payments to be made if the developer chooses to extend that option period. So during the option period, the developer is seeking exclusivity. The landowner during this period will be restricted from seeking other solar development opportunities. During this period, the developer wants to make sure that if they want to proceed, no one else can step in and step on their shoes. Usually during the option period, agricultural operations can continue on that premises. Oftentimes there'll be a tenant farmer working for the landowner. During the option period, subject to the needs of the developer, agricultural operations can continue as they did before. During the option period, the developer will require easements be granted for access to conduct their studies, and importantly, existing agricultural leases on that premises need to be subordinated to the solar option agreement, the solar lease agreement, prior to the landowner signing it. It's important to consider and understand that this creates an option for the developer, not for the landowner. The developer will have the option as to whether or not to proceed with the project. Once the landowner signs the agreement, it's more or less out of their hands. So after the option is executed, a construction period will begin. This is defined differently in different agreements that I've seen. Sometimes the construction period will begin when the developer serves a construction notice onto the landowner. Sometimes it'll be defined as when ground is broken in construction. And there's a case-by-case basis that we look at. So the developer will require a different set of easements during the construction period. They will want easements to allow for their construction, to allow access. At this point, agricultural operations on that parcel will need to be terminated. It's important for the landowner that any agricultural lease is terminated in accordance with the contract they have with the farmer or in accordance with Illinois law. And we want to make sure that there are terms in your renewable energy lease agreement that will allow for this. So once the construction is complete, and in these types of projects, the construction may never really be complete. The developer will reserve the right for themselves during operations to continue constructions, make alterations to the facility, and you may see construction going on, starting and stopping through the term of this agreement. The definition of when operations begin is also variable contract to contract. Sometimes it'll be when the facility begins generating electricity at a commercial level. Sometimes it'll be a fixed amount of time after the construction period begins. And this is something where you really need to look at the specifics of your agreement to determine when operations begin. The operations period is usually a very long term. We'll see terms of 20 up to 45 years. And the developer will almost always reserve for themselves the right to extend that operations period. In community type solar developments, the compensation during operations is usually based on a per acre per annum type formula. And they use a yearly escalator, which they apply to the per acre per year formula to increase that value of the agreement to the landowner over time. And this is in part to compensate for inflation, though you typically you will not see a yearly escalator that is pegged to the inflation rate. They will offer an amount that is less than that. And the reasons for this are that they, over the life of the agreement, need to be able to acquire funding. They need to attract investors, and they need to structure their finances in a way that's going to be acceptable to those lenders or investors. During operations, the developer will retain easements for operations, for security, maintenance, and ongoing construction, as I mentioned. So during operations, the developer will require peaceful enjoyment of the lease premises. What this means is that the landowner can't interfere with or obstruct their operations or allow any related party to do so. This can include restrictions on adjoining properties that that landowner may own. They're not going to allow you to engage in activities which is going to interfere with their operations on adjoining parcels. One of these concerns is, and what they'll ask for is an easement for the capture of solar radiation, which essentially means the landowner can't do anything that's going to interfere with their sunlight. They're not going to allow you to build tall structures on adjoining parcels that could cast shadows. They're not going to allow you to engage in activities that are going to generate an excessive amount of dust. They're also going to want an effects waiver from you during operations, where you're going to be barred from any cause of action that results from an effect of the project. That would be glare, vibration, noise, electromagnetic interference. Now you can't get reception on your cell phone. They're going to want you to waive cause of action based on these. So how does a solar lease agreement terminate? Typically, the landowner is going to be restricted as to how they can terminate the agreement. Usually, the landowner will only be allowed to terminate in the case of an uncured monetary default, meaning the developer didn't pay the rent as stipulated under the agreement. Bankruptcy or insolvency of the developer alone is usually not going to be enough for the landowner to be able to terminate the agreement. There would also have to be an uncured monetary default there. We're bankrupt and we didn't pay you. On the flip side of that, the developer reserves for themselves the right to terminate the agreement under a variety of circumstances. During the option period, they're going to reserve the right for themselves to terminate the agreement at will with no additional compensation or money being owed to the landowner. For them to terminate during the operations phase, this is going to be a contract specific type term, and you'll see different conditions and results for the developer of terminating the deal early. Sometimes you'll see an early termination fee. That's something that we look for as being positive for the landowner. So another question that I often get from clients who are looking at signing these types of agreements is, how are they going to guarantee for deconstruction, for removing the infrastructure that they build from my property? What are their land management practices going to be during operations? How are they going to restore the ground once they're done with their operation and the agreement's terminated? So, a concern for landowners is that there's adequate money set aside in escrow to provide for deconstruction, even in the event that the developer may be insolvent or go bankrupt, and maybe there's no continuity of interest in the development. So the way that we do this, best practice, is that we require an AMA agreement be incorporated into the lease agreement itself. AMA is an agricultural impact and mitigation agreement. This is overseen by the Illinois Department of Agriculture and serves to guarantee the availability of funds for deconstruction and stipulates land management practices during operations. If this language is not included in an agreement, this is a red flag to me. This is something that I like to insist upon. There will be a deconstruction period at the end of the term of the agreement. Typically this will be a 1-year period where the developer or the successor in interest of the developer will have time and maintain the easements required to remove the infrastructure that they've built and restore your land to pre-construction conditions. One thing that landowners are concerned about is, how do I transfer the interest in my land to my heir, to a buyer while this lease agreement is in effect. So typically, the developer puts in place extensive protections for themselves to be able to transfer or assign their interest in the lease. This might be through a bankruptcy or an insolvency proceeding, or this could just be through normal buying and selling, investing, mortgaging, all things that you would expect would occur over the lifetime of this agreement. As the landowner, you will definitely be required to acknowledge successors in interest and cooperate with them reasonably in their aims. The caveat here is that the person or the entity who accepts assignment or transfer of the interest in this lease agreement is going to also have to accept the terms of the agreement as they were when you signed them. Then they'll be bound by the terms as executed. So, benefits of solar lease agreements for landowners. What I like to see in an agreement, what I typically insist on, and a well-structured agreement, is going to provide adequate protections for a landowner's interests in any or almost any foreseeable situation. It's going to allow for the legal termination of existing agricultural leases that you may have with tenants on your land, which encumber the property. The agreement's going to make provision for a continuity of operations of the project, no matter if the developer becomes insolvent, goes bankrupt. And we want to make sure that you're not going to be left in the lurch. The agreement should allow for flexibility for the landowner to sell or transfer their interest to a buyer or an heir without impediment. One of the big advantages of these agreements for landowners is that they have the potential to provide a long-term and substantial income for the landowner, for their heirs, exceeding what could be expected from an agricultural lease or continuing to use the land in agricultural operations. We also want to ensure that any unused portions of the leased premises and adjoining parcels may continue to be used for agriculture unimpeded. Burdens of solar lease agreements on landowners. It's very important in order to make an informed decision that the landowner understands what the burdens on his real estate are going to be. These are long-term agreements. The terms can extend to 40, 50 years. We want to understand what the limitations are going to be. The landowner will largely lose control over the lease parcel once the agreement is signed. The landowner is not going to be able to easily terminate the agreement. They're going to have to grant easements to the developer over the lease parcel and possibly over adjoining parcels. They're not going to be able to, the landowner's not going to be able to control whether or not the developer actually proceeds to operations. That's the nature of an option agreement. One thing that is of grave importance to the landowner are tenants' rights issues concerning existing agricultural leases. This must be addressed prior to signing the solar lease agreement. If you have a tenant farmer on your ground, his lease agreement needs to be subordinated to the terms in the solar agreement. He or she is going to have to agree to this. As I mentioned, long terms, which are binding on your heirs and on transferees. They're going to be bound by the same terms that you are when you sign. Oftentimes, these agreements will require the landowner to carry commercial liability insurance. This isn't in every agreement, and obviously I prefer agreements where the landowner isn't required to insure themselves, but oftentimes the developer will insist upon this. We touched on the limitations on the use of adjoining parcels that you may own. You're not going to be able to build any tall structures near the property line. You are going to have to waive setback requirements to the extent that's allowable under law. This is going to allow them to build their project right up to the borders of land that you may have adjoining the lease parcel. They're going to insist on waivers of recovery for damages in certain forms. They are going to require that you waive the right to recover punitive damages or special damages that may be incurred due to the fault of the developer. The most important burden to consider is that as the landowner, once you sign this agreement, you are committed. Don't sign a renewable energy lease agreement until you're certain that it's in the final form, an acceptable form, and that you understand totally what you're signing. So, why seek legal representation when you're considering signing a solar lease agreement? A competent, experienced attorney is going to help ensure maximum landowner protections over the full life of the agreement. The attorney is going to create complete situational awareness in the landowner, considering the specific terms in a particular agreement. You'll know what you're signing if you hire a lawyer. The lawyer will be able to advise as to terms in the agreement which are favorable to you, terms that may be there that aren't so favorable to you, terms that are standard and commonplace, terms that are exceptional or unexpected. And the attorney can offer professional advice as to amendments and revisions. The lawyer can provide you with insight into your particular offer in congruence with your long-term goals so you can make an informed decision with confidence. Having an attorney represent you in negotiating these deals can help get the landowner the best possible compensation terms over every phase of the agreement. We do this by drawing on our knowledge of industry standards and local variations. An attorney can act as the liaison between the landowner and the energy company representative. A reputable and experienced attorney can advocate for you and negotiate on your behalf from a position of strength and experience. Often, solar developers will be willing to reimburse the landowner for attorney's fees that they incur in these contract reviews and negotiations. They'll require that these reimbursements take place if and when the landowner executes the agreement. Many clients that I've talked to about their experience with our representation in these matters feel that the fees we charge are more than offset by their guarantees of maximum safeguards and the increased value of the lease agreement that the landlord will usually gain from adequate representation in the process. So that wraps up the body of my content of this presentation. At this time, I would open up the floor to any questions, which I'll be happy to answer at this time. If you have received a proposal from a renewable energy developer, now would be the time to seriously consider hiring an experienced attorney to represent you in these matters. We'd be happy to talk to you here at Woods & Bates in beautiful Lincoln, Illinois, to discuss your individual situation. Do we have any questions on the floor?
Brent, I have a question.
And
what kind of compensation is fair in these agreements? What did the developers usually offer? What is a good yearly escalator?
Well, the terms that a developer is going to offer to a specific landowner in a specific agreement is going to be based on the locality of the project, on the developer's cost and profit projections for that particular project. And something to consider here is that compensation term structures vary. Value may be gained in one form, in one part of the contract, at the expense of value in another term in another part of the contract. For example, a lower per acre per annum rent offer, could be offset by a more generous yearly escalator, which would increase the value of that agreement to the landowner over time. one of the things an experienced attorney can do for you, representing you in these types of agreements, is help you understand what compensation might be reasonable concerning the totality of the terms in the contract. Generally speaking, developers will be somewhat flexible in the compensation terms that they offer, whether or not this is during the option phase or operations. And, an attorney can help you negotiate the best possible terms they're willing to offer.
I do have another question if there's not anyone else for a question.
Go ahead.
Oh, you can hear me. Okay. So I think in layman's terms, is it basically what it sounds like to me is you're almost, if I'm the landowner, I'm almost signing over my land, but to be used by this solar energy company, and they're basically using your land, but you still own it. Is that correct? And then you get like a kickback every year?
That's more or less correct. What I'll clarify there is what they are getting from the landowner is a leasehold interest. They are getting what we call a present possessory interest in the real estate. The landowner retains the residual interest, the future possessory interest at the conclusion of the term of the agreement. What they are offering you in compensation for this is not so much a kickback, but compensation based on a structure that's going to be clearly defined in the agreement. Typically, a per acre, per annum type formula in solar lease type agreements. You are signing over a good deal of your rights during the term of the agreement. You will retain some rights. You may be able to still access the premises. You may be able to have contractors that work for you still access the premises. These are details that are going to be contract specific, and you would have to actually look at your particular offer to understand what rights you're giving up exactly and what rights you're retaining in your real estate during the agreement, during the lease term. Is that about?
Yeah, makes sense.
Okay. What happens if I sign the agreement, but then I want to get out of it?
So, this is something the landowner has to be very careful about, because once these agreements are signed, there's very limited options for the landowner to be able to terminate it. And, the reasoning behind this is that these developers make a substantial investment in these projects, not only during construction and during operations, but prior to that, during the option period, and even before that, you've signed your contract, they've already made a substantial investment. So they will put extensive protections into these agreements to make sure that they can continue their project, that they can generate the profit they're expecting to get to justify the expense that they're putting in. The landowner typically, as I mentioned before, is only going to be able to terminate these agreements in the event of a material default, meaning a substantial non-compliance with the contract, or a monetary default, meaning a failure to pay the rent. And oftentimes you'll see a term there where a financial default must be adjudicated before the landowner can terminate, meaning they want to be able to take it to a panel or a tribunal. They want it to be arbitrated before they'll allow you to terminate. Once you sign this agreement, very difficult to get out of it. It's one of the burdens of this type of lease agreement.
Thank you.
One more question.
What do we got?
Why don't they just offer to completely buy the land from the landowner instead of or is this more who wins financially in this situation? Is it more profitable for the solar company if they do it this way?
So, one of the reasons why they don't just buy the land outright is because they need to conduct a series of surveys and studies on the ground to determine the ultimate feasibility of their project. And they do this during the option period of the contract, where they haven't actually built anything, they haven't begun operations. They're determining whether or not it's going to be financially viable for them to go forward on that particular parcel. And rather than buying that ground outright, they lease it and give themselves a period of time to determine. They already suspect, they already think that this parcel will be appropriate.
Okay.
During that initial phase, they conduct the studies and tests to know with certainty. If they bought the property outright, now they're stuck with it, whether or not they can ultimately use it or not. That would be one reason.
During this grace period where they're doing that, if they determine that it's a good piece of land and like optimal for what they want to do, why continue to lease it? Or do they just why wouldn't they offer to buy it outright, especially if it's a 40-year deal?
There are certain tax incentives and statutory incentives, that incentivize them to do it this way.
Okay.
It makes more economic sense for the developer to lease this ground from a landowner for the term of their operations. It ends up making more dollars and cents for them because of the way that the taxation system is structured. It's to their advantage to do it this way.
Yeah, gotcha. Thanks.
You're welcome.
Okay, so there was another question, and it kind of goes hand in hand with my next question. I was going to ask, who pays the taxes on the land, the landowner or the developer? And then there was a question in the chat that said, what tax credits would be available on that as well?
Okay. So how taxes are paid will be stipulated in the agreement, and there is some variance here from agreement to agreement. What I like to see is a structure in the agreement where the developer will obtain a separate tax ID for the parcel that they're actually going to use for their project. That they will be responsible for the taxes assessed on the value of their infrastructure that they build, or an increase in the taxable value of the underlying land due to their developments or due to a reclassification of that real estate that might occur due to their operations. And I want to see the developer being responsible for paying the taxing body directly without the landlord having to be the middleman. As far as tax credits are concerned, the developer, in my experience, will always reserve the right to any tax credits for themselves. And the landlord, the landowner, will need to disavow any claim to any tax credit that might be granted due to their operations.
He had a follow-up. You can go ahead and ask him.
Okay. Hi, Brett. I wanted to first thank you again for this. This has been really helpful.
So, sorry that I let you in late.
No, that's all right. No worries. I wanted to actually ask about the risk in signing up with one of these developers. It seems, at least from the news that I'm hearing, that things are really changing in terms of how much support these people can expect to get when they build out these projects. And my assumption, I don't know, but my assumption is that they're relying on a bunch of government support to make this thing profitable. And you said, at least the part that I heard, that they have different parts of a potential lease agreement. Part of it is going to be to figure out whether or not this is going to make money for them. And then there's an operations piece. So I'm just trying to understand, do you think there's a bigger risk now in signing up with one of these developers than might have existed previously because of them not knowing what might be happening?
I think that particular concern is a consistent and ever-present risk. We are always at the mercy of changing legislation. Your comment about their profitability being dependent on government funds, on government incentives, that's a correct assumption. The risk is that their project will become unprofitable and they will terminate the agreement. That risk is going to be present for the landowner. It's going to be present for the landowner who signs these types of agreements 10, 20 years down the road. That's why it's important to understand what the situation is going to look like if the developer does elect to terminate. Some of these agreements will stipulate that in the event of termination by the developer, nothing else is owed to the landlord. The only obligation that they owe you at that point is to deconstruct their infrastructure and restore the land. Other agreements will afford the landowner an early termination fee. And that's dependent on the specific agreement that you're looking at. And, those are some of the terms that we typically negotiate over and try to get a favorable result for the landlord.
Okay, if there wasn't any other questions, I think that might be it, Brett.
All right. Well, if anybody listening today has any follow-up questions or has one of these agreements in their hand, if you've been approached by a developer or if you know someone who has, a family member, we here at Woods and Bates would be happy to assist you. I would personally be happy to assist you and help get you the most solid and profitable deal that you can for your contract, for your real estate that you've worked hard to acquire and maintain, and that you want to be productive and profitable for your family in the future, for your heirs. Give us a call here at Woods and Bates. Thanks. I'd like to thank everyone for attending today, and maybe I'll be hearing from some of you soon. Kate, thank you.